Okay, clock struck 10. So welcome to another session in the oral argument for the 5th District Court of Appeal. I assume y'all can hear me?
Yes, Judge.
Okay, very good. I am Judge Lambert. I'm Chief Judge of the court right now, and I'm presiding over the this oral argument this morning. On the panel with me, you can see on the Zoom oral argument, is Judges Wallace and Edwards. This is the case, this is December 6, 2022. The case number is 21-2978, Connie Ader, A-D-E-R versus Home Depot USA, Inc. Each side will have 20 minutes for their oral argument. You see the clock, it's up in my upper left corner here. It shows the 20 minutes. The appellant, we will reserve 5 minutes rebuttal unless you tell me otherwise, and then I'll have the marshal or the marshal's office change the rebuttal time on the clock. It'll start beeping yellow or flashing yellow when you get any rebuttal time. When you get to your end of the time, the red light will be flashing. We are on YouTube, so we are in theory being watched. So I say that, just remember that when you're talking to us. And also, if you have any type of electronic devices, cell phones or what have you, please turn them either off or into the mute position so as not to interfere with either your argument, your opponent's argument, or the court. All right, that being said, we're ready to proceed. Is it Mr. Redavid?
Redavid, Your Honor.
David, excuse me, I apologize. I don't make that right. Redavid.
Quite
all right, counsel. Whenever you're ready, go ahead and proceed.
Thank you, Mr. Chief Judge, Your Honors. Good morning, and may it please the court. I'm Jordan Redavid for Connie Ader, who's the appellant cross appellee in this case, and I would like to reserve those 5 minutes for rebuttal, please.
Very well.
Although our brief raises multiple issues, some of which don't reach to the heart of whether a new trial is warranted, I'd like to discuss 4 issues this morning primarily as to why a new trial is warranted. They are, in order of how I'd like to discuss them: the trial court's handling of the spoliation of the basket at issue, Home Depot's closing argument, the trial court's mishandling of the Binger issues, and the issue of punitive damages. Focusing in first on the spoliated basket. This is a case where it is undisputed in the record below that my client was injured in the Home Depot store, that a contemporaneous report was made. My client made an incident report. My client's husband brought Home Depot's on-site management to the site where the incident took place and showed the harmful basket. More than that, there's testimony from Wendy Borden, the on-site manager for Home Depot, that my client was, quote, threatening lawsuit, said, quote, they'll have to pay for that. And
Mr.
that she—
David, when did you or anyone on behalf of your client make a request for Home Depot to preserve the evidence?
I don't think the record, well, pardon me, the record might have our firm's initial written request, which was admittedly, I think, several weeks after the date of incident. I don't have
months.
It was well after the incident. I don't want to misstate. I believe the document, the one-page letter, is in the record, but I don't know the relation of the time. It's our opinion, though, that letter is not what the court should focus on as to whether or not the trial court made a proper legal ruling. Here below,
Counsel, how do we deal with the fact that your client testified at trial that she never said she was getting a lawyer to the people at Home Depot?
right. So there's an issue of credibility there that is best reserved for finders of fact, which were the jurors. The issue here, though, is that
Well,
the
when it
trial
comes to
court—
spoliation, the judge has to take all that into account. I mean, if somehow during the trial he changed his mind, I mean, he may have given a different instruction on spoliation. So
the issue here that's on appeal is whether or not the trial court was correct to say that Home Depot had no duty to preserve. The secondary issue, of course, related to that is to what extent, if any, remedy should have been given. But I want to focus first on the issue of duty, because the ruling here was that Home Depot had no duty. And our position is, under well-established Florida law, that on facts like this, as applied to Florida Supreme Court cases like the League of Voter Detzner case,
Counsel, in the League of Voter, that's a different situation. Doesn't the Supreme Court there say that litigation was a certainty?
I believe that is language in the opinion, but the heart of the opinion is that when litigation is reasonably foreseeable, and in that case, the Detzner case—
the holding of the case, and there's a case from our court that says that's not the holding. Isn't that correct?
That's true, Judge, but when the Florida Supreme Court expressly cites to opinions out of sister circuits like the sister districts like the Fourth District Court of Appeal that affirm the principle that when litigation is reasonably foreseeable, it can trigger a duty. The problem here is that the trial court said Home Depot had no duty. And if we're to live in the environment where an offending defendant in a store is contemporaneously put on notice before the claimant leaves, that person fills out an incident report. Home Depot, the offending party, hears own testimonies that she was threatening lawsuit. And I think most important here is Home Depot's internal policy, which says that when these claims take place and they fill out the incident report, it's supposed to be preserved. Not only is there no dispute of that, the on-site manager, Ms. Borden, said she removed the basket to specifically put it behind the desk for preservation. And then we don't know where it goes.
Mr. Reed, David, was your request or your client's request to preserve the evidence, was that sent to Home Depot after you filed the lawsuit?
I believe I don't believe so. I believe the written notice from my firm, which in fairness in the record, I think is the only explicit request of preservation, was sent, I believe, before the lawsuit was commenced. But I don't think there's any evidence in the record that my client expressed, like in the Walmart case from the Florida Supreme Court, where the claimant told the store, please preserve the shopping cart in the video. There's nothing in the record that suggests Mrs. Ader expressly requested the preservation here, but the issue here is one of duty. And I think on this record, in light of what the law is trying to accomplish through the reasonably foreseeable doctrine, we have a situation where Home Depot had a duty. So the next question then is,
excuse me, counsel, what case creates this duty when it's just reasonably foreseeable as a holding in the case?
Well, as Your Honor said, the holding of the combination of the Walmart and the Detzner legal voter opinions, in my position, holds that the reasonably foreseeable doctrine is something that when the right facts fit into it can trigger duty. Although I'm not suggesting those cases explicitly say anytime there's a defendant on notice of an incident in their store, it automatically triggers a duty. I think it's a fact intensive inquiry, but I do think it's within the combination of holdings from the legal voters and the Walmart case. The issue here is whether or not the instruction that was ultimately given to the jurors, of course, was sufficient. Our position is that the trial court erred when it said that Home Depot had no duty to preserve, but nevertheless, an instruction was given. It was permissive. It told the jury, in essence, you may, but are not required to infer that the missing basket would have been unfavorable to Home Depot. I think in a vacuum, it's easy to say that that instruction may or may not, meaning it's debatable as to whether or not it's sufficient. But as applied to this particular case on this particular record, especially the arguments made by Home Depot at trial below, it shows why it's inadequate. There were multiple instances in the record where Home Depot's counsel basically either tried to shift blame onto Mrs. Ader. There were comments like, well, she didn't take any photographs of it. There were other comments where Home Depot almost tried to seize and weaponize its own spoliation to show a benefit. For example, there were comments to the jury that, well, when Mrs. Borden saw the basket, she didn't think enough of it to take a picture. Therefore, there must not have been anything wrong and things like that.
Mr. Reed, David, what would be the remedy that you're seeking on appeal specifically with regard to the spoliation of evidence issue?
On remand for a new trial, it would be with an instruction that the rebuttable presumption, more akin to the Valsian presumption, is what was proper, not the permissive inference that was given.
Under Florida law, don't you have to show that the product was lost intentionally or intentionally disposed of?
Intentional, I think bad faith is a consideration. I think we have those things here on a record. When you have
What's the record of intention? What's the record of intentional? I mean, it was behind they took it, put it behind the counter, and then they lost it. I mean, it certainly sounds like it could be negligent.
Well, I think here's the problem. When we have a situation where it's undisputed that Home Depot's management is preserving it with the express intent setting it aside rather, with the express intent to preserve it pursuant to policy, it cannot be that the defendant in that scenario can just say, we can't give you an explanation, it just disappeared. I think that rises above mere negligence. To me, this is mere negligence. Negligence is when the janitorial staff who serves the midnight shift says, oh, I saw it behind the desk, I thought it was trash, so I threw it out.
How do you know that didn't happen?
Well, that's the point here, is that the spoliator can't be entitled to both the benefit of saying we spoliated, and because you can't prove why we spoliated it, it must always be a situation that you're never entitled to a Valsian presumption. I think on the facts of this case, our position is the ruling should be there was a duty to preserve, number one, and so that ruling was wrong. And number two, on these specific facts as applied to the spirit of the law, that the Valsian presumption is more adequate. I'd like to move now to the issue of Home Depot's closing arguments, specifically as it relates primarily to Home Depot's counsel telling the jury in closing that if you use the methods that the plaintiff was arguing in closing argument to come up with the damages formulation, that's how you get billboard numbers. The reference to billboard being to plaintiff attorney advertisements. There are two components of this that I think make this exceedingly problematic, even in an isolated instance of one comment where it was objected to. The trial court did sustain the objection and give sua sponte some modicum of a curative instruction, but I think that's insufficient for two reasons. Here's why. Number one, on this record.
Before you get to the two reasons, I have a question for you. When the court sua sponte gave the curative instruction, did plaintiff ask for any further curative instruction?
No additional curative, no modification.
And at that point, did plaintiff move for a mistrial?
No.
Okay, then how do you say that this is a preserved error for us to even consider?
Well, I think even if this court were to fall back onto the fundamental error analysis, at the end of the day, what is fundamental in error but that which is definitively harmful and that which reaches to the heart or foundation of a case? In a plaintiff personal injury case, on average, not this case, but any case, obviously we are highly sensitive in trial courts so that the plaintiff is not insinuating to the jury that there's insurance or that the wealth of the parties, let's say it's a big company or something like that, that should never be in evidence. I've never had a case before this one where the defense took it upon itself to make the plaintiff, to analogize what the plaintiff was asking the jury to do was to put them on a billboard in essence. Here's a unique situation of this case, which takes it out of just a routine hypothetical. We know what the comment was made. Here's why, if anything, it's still fundamental error, even if that's the analysis. In voir dire, when the issue of attorney advertising was brought up, and there were many, many damaging comments made by potential jurors at that time, when it came time to do cause challenges and the plaintiff started moving for cause on prospective jurors who had very negative feelings about attorney advertisements, it's Home Depot, in fact, the same lawyer for Home Depot who told the court, you shouldn't really consider that as a basis of cause challenges because attorney advertising and billboards have nothing to do with this case. Now, flash forward a few days later, it's that same lawyer who, after three primer comments, which are in our brief about remember and voir dire, then says what you just heard from the plaintiff is how you get billboard numbers. I think what you have here is.
Let me ask you some other questions about in your brief at page 28, you said that Home Depot in its closing argument said, I hope we have given you the impression we've been fair. I didn't come in here and talk about $20 million.
Yes.
You say that's Home Depot that made that comment. Do you know that that's really Mr. Fisher, your partner, that made that comment?
If that's an oversight, I'm very apologetic.
Well, and then the next comment was, you say you didn't object to it. Well, why would you object to it? It was your law partner that made it. Then you said that Home Depot said that basket must be worth $1 million because it's not in the courtroom. You want to tell me who said that?
I'm going to infer from the question itself that it's my partner, and if it was, I apologize. That's obviously a gross oversight in the briefing process.
That's a misrepresentation. The next comment is where they were saying that they were faulting the plaintiff, and once again, that was your law partner making that comment. Do you think we should reverse for a new trial because your law partner made inappropriate comments in closing argument?
No, of course not. And obviously,
why are you telling this court then that it's Home Depot saying that thing?
Well, I'm telling your honors this morning that if that's the mistake that I made, then obviously you shouldn't consider it as a basis for a new trial, but that's not the billboard comment. And I don't think there's any dispute here that was the billboard.
The billboard comment wasn't preserved under what Florida law requires.
Well, but even if this court, like I said, even if this court were to fall back to a fundamental error analysis, the question we have to ask ourselves in this case, knowing what the implications will be of any ruling on the case, is, are we to countenance and implicitly approve of one side or the other getting one free pot shot of a highly derogatory and inflammatory comment in a personal injury case? This was not, for example, some
how
offhand.
Does this reach down to the core here? I mean, the way I read the record and the way I read y'all's briefs, there was a lot of dispute over the nature and extent of the injury in terms of whether it was a scratch, whether it was a laceration, a puncture wound. You hear scratch and then you see the photograph after the physician's assistant puts 8 staples into it, and it's hard to imagine that was a scratch before he started with it. You then see the initial nerve conduction study saying nothing, but then later on there's something. I mean, there were a lot of disputes both between the nature of the injury and the ultimate effect of the injury. And the jury then heard all this conflicting testimony and then came out where it did, correct?
I agree with you entirely. And it's for those exact reasons that you just enumerated is why Home Depot's unnecessary reaching to the heart of the case, into the heart of the case to tell the jury, put aside disputed issues, rule on your prejudice against plaintiffs and plaintiffs' attorneys. Remember, the comment was not billboards in a vacuum. The comment was after Mr. Fisher just gave a first part of closing argument, if you use their formula, their recommendation to calculate damages in an admitted liability case where causation, at least in part, there was directed verdict. So the issue was money and how much to give. If you follow them, that's how you get billboard numbers. What you're really telling.
But counsel, you need to understand, we're here to correct the trial court's error. When the
Right.
trial court heard that comment, heard the objection, the trial court sustained the objection and sua sponte gave a corrective instruction, a curative instruction. Nobody asked for anything different. How did the trial judge get that wrong? Should the trial judge have just up and immediately declared a mistrial and tell everybody to go home?
No, I'm not. Our position is not that.
What remedy would there be?
Well, we brought this to the trial court on a motion for new trial as well. It's not like we just went from trial directly to your honors. And when the trial court was presented with this, when there was a memorialization of the record definitively to go back on, that trial court also erred in denying the motion for new trial as it relates to that comment, which was within that motion. I think at the end of the day here, the primary concern is this. Well, even assuming, and I'm acknowledging that there was no request for a different curative and there was no request for a mistrial contemporaneously. Here's the problem if a remedy of a new trial is not warranted for a comment like this. It lends itself in a very slippery slope way to say that, well, each side gets one free pot shot. Next, it's going to be a plaintiff's attorney who knowing better tells the jury in closing argument, look, if you listen, let's say it's a rebuttal argument. If you listen to what the defendant just told you and you follow their advice, that's how you get insurance company numbers. Objection sustained. And if that defense counsel doesn't move for mistrial, then the position, of course, will be here from a preservation standpoint. I don't think, given how, given that we have the same offending attorney acknowledging earlier in the record during voir dire that he knew this had nothing to do with the case. I don't think with these specific facts we can get past it. The third reason, though.
I mean, you're getting into your rebuttal time, and I don't want to cut into that. Do you want to talk about the cross appeal now, or just wait for your rebuttal?
I can wait for my rebuttal to give the other side an opportunity to set it forth. I'll yield the rest of my time for that purpose. Thank you.
Thank
Okay.
you. May it
Cal?
please the court, Daniel Weinger on behalf of Home Depot USA. I guess I'm gonna try and go in reverse here just to piggyback onto the more recent discussion. I think it's important to point out there, and the court seems to understand our arguments that were exhaustively briefed, so I'm not going to get too into the weeds on this, but there were actually two waivers, not just one. The court did point out that even the one instance where there was the objection, it was sustained, there was a curative sua sponte given by the court that there was no motion for mistrial or request for an additional instruction, that as to the billboard issue was the only objection raised. The issue of fundamental error was not raised in appellant's initial brief. And we cited in a footnote, I believe, in our answer brief that you can't raise fundamental error for the first time in a reply brief. So even were the court to consider, and I don't think, and we briefed the issue extensively, that this would amount to fundamental error, what the closing argument in this case, even if that were true, it wasn't properly raised on appeal here. So there's really, our position, other than that, is it's been fully briefed pretty exhaustively, and the court seems to understand our position, but I'm happy to answer any questions with regard to the closing argument, or else I'll move on.
Counsel, you agree that was a totally inappropriate comment, don't you?
I do think it was an improper comment. I don't think it was fundamental error, and I do think it was corrected immediately. So, but in hindsight, yes, it probably is a comment that shouldn't have been made. I do take issue with relating it back to voir dire. Most of the comments from voir dire that were cited to in the brief were not actually made by either attorney. They were just comments that were made by the jurors. So to try and hold us accountable for those comments, I don't think is proper. But again, there was no preservation here. It wasn't something that pervaded the entirety of the closing argument. It was just one throwaway comment that was nipped in the bud immediately. As far as the spoliation, I think the court hit it on the head. The Desner case does allow, in extreme circumstances, to find that there's a duty when litigation is certain. But even if we assume, for purposes of this discussion, that a duty did arise here, as counsel pointed out, and he wisely tries to skirt the issue, the adverse inference instruction was given here. The next punishment up, even if there were some evidence with which the court could have found that there was an intentional spoliation, and there wasn't any such evidence here, but even if that were the case, you still have to be able to show prejudice to get the Valson presumption, which wasn't the type of prejudice that's required, simply wasn't shown here. It's to put the parties on equal footing because either a plaintiff in presenting their case or a defendant in defending their case is completely prevented from making out a prima facie case or defense. And that's not the circumstance here. Ultimately here, the argument, as far as the basket was concerned, because additionally liability was wound up being admitted in this case, so it was strictly an issue of damages, was
counsel,
whether or not
actually,
yes.
there was an issue of causation as well, and that to me seemed to be where the spoliation came in with this case, because I think defense at various times made the comment, maybe not the exact words, but that basket couldn't have caused that injury. And I think that's where plaintiff really feels that they were prejudiced with the spoliation. If they had the basket and whatever piece that was that may have been hanging down or sticking out, then I think they said they would have had a stronger case perhaps to show it could have caused a puncture. So I don't think it's just the fact of liability. The causation issue does go to the spoliated evidence.
But to that extent, that's why an instruction was appropriate instead of just allowing counsel to argue for an adverse inference, which is kind of usually the default. And the court did give the instruction here, but at the end of the day, plaintiff could make out a prima facie case. The jury awarded past damages. So that in and of itself shows that causation of some kind was established. So, clearly the plaintiff was able to make out a prima facie case.
Mr. Weinger,
yes.
As far as reasonably anticipate or reasonably foresee litigation, in this case, we have the appellant making the statement, according to Home Depot, that she intended to sue. And the next thing that we have is the letter requesting to preserve the evidence. So short of filing a lawsuit after your client received that statement or heard that statement about intending to sue, what other information or evidence was the plaintiff required to provide to you, short of filing the lawsuit, to overcome the burden of reasonably foreseeable?
Well, I guess to a certain extent, I take a little bit of issue with the reasonably foreseeable test to begin with, because other than the League of Women Voters case, where the court took that extra step and said not just reasonably foreseeable, but litigation was a near certainty. Other than that case, the overwhelming majority of case law, and there is some inconsistency, but the overwhelming majority of Florida jurisprudence is that unless there's a statutory or contractual basis that establishes a duty to preserve, until a lawsuit is filed, there is no duty. And with the adverse inference instruction, though, you don't necessarily need the duty. Even if you're perfectly innocent, the plaintiff can get an adverse inference instruction. It's taking that extra extra step to Valson, where you're shifting the presumptions that the duty and the intentional misconduct or not intentional misconduct comes into play. And I appreciate the court's hypothetical, but we just don't have that here.
So your position would be that even after the letter requesting to preserve the evidence, even after that letter was sent, if a lawsuit had not been filed, Home Depot had a window in which it could choose not to be careful and preserve the evidence. Is that correct?
If you were to hold me technically, that would be true, but in reality, you'd likely meet the Dessner or the League of Women Voters test of litigation being a near certainty once you have that type of letter. So that's why I said the League of Women Voter case kind of creates what seems to be a new rule on the issue of duty prior to litigation, but you still at least need a letter or something taking you to that level of litigation being a near certainty, as opposed to just reasonably foreseeable. But again, I go back to, even if there were a duty, the appropriate sanction here would have been the adverse inference instruction, which was given. Unless the court has any more questions on that, I'll move on to our cross appeal. Looks like I'm.
Go ahead.
One more. Okay, terrific. As with the arguments that were raised by appellant, the cross appeal we did extensively brief, but while I have the court's attention, as long as we're here for oral argument, anyways, without going verbatim through every little detail of what went on here, I did find it interesting in Judge Edwards' questioning about the discovery, as far as the closing argument, the discovery misconduct here directly relates to, and it's been raised a couple times now, the issue of causation. It goes to the heart of the case, and that's exactly what the trial court found in its holdings. I recognize, the defense recognizes that it is an extremely high burden to dismiss a case or strike a party's pleadings for fraud on the court. However, and the court is given, the trial court's given a great deal of discretion, but I don't know how one can reconcile the factual findings that the court made with the decision to not strike the pleadings for fraud. And those factual findings are that the symptoms the plaintiff complains of in the lawsuit are notably similar in several respects to those alleged in the currently pending federal lawsuit in which she was represented by the same attorneys. She did not disclose in discovery responses the federal litigation, despite being afforded multiple opportunities to do so. It is unexplained how plaintiff could disclose a minor car accident that occurred decades ago, but failed to mention the production within the last year to her attorneys of quote unquote a ton of medical information related to potential federal litigation regarding Levaquin and Cipro. It is likewise unexplained how this omission was unnoticed and uncorrected by her counsel, who have represented her diligently throughout the case. As a result, the court must find that both plaintiff and her attorneys had knowledge of the federal litigation when they provided the discovery responses. The court must find that both plaintiff and her attorneys were given adequate opportunity in discovery to inform Home Depot of the federal litigation. Taking all of this together, the court cannot find that the failure to disclose the federal lawsuit was unknowing. And based on the total record of this court, plaintiff's failure to admit that she was involved in the federal litigation would not have been corrected if Home Depot had not filed the instant motion.
Counsel, let me ask a couple of questions just to make sure I'm clear. The Home Depot suit was filed before the federal lawsuit. Is that correct?
I believe that is correct. Yes.
And which means that the federal suit was pending, and that was a suit that Mr. Redavid or his partner, Mr. Fisher, or somebody else in their law firm, they actually filed a suit in federal court, correct?
Correct.
This is not a situation where you get a postcard at home saying, congratulations, you're a member of a 10 million class action. They actually filed a suit in federal court, correct?
They filed a lawsuit, had hundreds of paragraphs in the complaint.
All right. And as the trial court in this case found, the plaintiff, Ms. Ader, actually provided documents to her counsel so they could file that suit, correct?
Correct.
Okay. And they had numerous opportunities to disclose that or clear that up, and they didn't take that until the motion was filed?
That is correct. I will point out in all candor, and it was mentioned in our brief as well as theirs, that there was an issue as far as a discussion that took place after several discovery violations off the record between my partner and counsel for plaintiff, where there's difference, he said, she said story of what was actually disclosed. The conversation did kind of turn the radar on of my partner, which is what got him looking to see if there was something going on in federal court related to this case. The court specifically found that that discussion played no part and never made a finding as to whether, I think the court said, I'll just for purposes of ruling on the motion, I'll accept as true that there was an informal disclosure, far into the case. But again, the court never made a ruling on that. And
But if anything, that meant that plaintiff's counsel was aware of it. It hadn't slipped the mind. That's the position you took?
yes, and that, there was additional deposition of plaintiff after that never during a break did she come back and say, oh, I forgot to mention this. So we were never able to question her about.
Okay. And how do you say that this meets the extremely high standard or high burden requiring dismissal?
Well, it's discovery that really goes to the heart of the case. We keep the panel keeps asking questions about causation, and that you at the same time that plaintiff is claiming that whether you call it a scratch or a laceration caused significant nerve damage, injury, and numbness and tingling and issues with her arm and shoulder and whatnot. At the exact same time, she has a parallel case going on in federal court against two drug manufacturers, attributing the same conditions to issues with those drugs. And it could turn out that there are distinctions and that there are reasons, or that one impacts the other, but that's what discovery is for. And that's for us to be able to make a defense. And that really does go to the heart of plaintiff's case, because without the nerve damage, the alleged nerve damage, this was just a deep but scratch on the arm case. And, had we not discovered that, for the jury not to have known about that.
Mr. Weinger, I believe you would have to agree with me that scratch, that's your interpretation of that. Don't you agree with me that a jury should be able, and we're calling the jury to look at the evidence and interpret the evidence how they would view the evidence? You and your experts can help them, and by trying to describe the evidence, but the jury is open to look at that picture with the 8 staples on it and make a determination whether or not they think it's a scratch, correct?
Absolutely. And if I tried, whenever I said scratch, to also say laceration, or however it winds, whatever the finding is, because I did not want to. I was paying attention when plaintiff's counsel was going. I'm not trying to diminish by saying for sure that's just a scratch. That's not what I intended to do. I agree with Your Honor. So at bottom, our argument is that the type of discovery and the finding by the trial court that the non-disclosure and repeated testimony under oath denying the existence of any other litigation goes to the heart of the case. Once you have the finding from the court that this was intentional and knowing, whether you're the trial court or this court, it's easy to conclude that it goes to the heart of the case, and that's what you need to sentiently set in motion an unconscionable scheme. And that's the essence of the argument we raised below. We still never got an explanation for exactly why this type of conduct, knowing and intentional conduct, did not meet the standard. Unless the court has any further questions, we'll rest on our brief.
Okay, thank you, counsel. All right, rebuttal.
Yes,
Motion.
judges, on the issue on cross appeal as to the fraud on the court motion, the legal ruling that this court's being asked to review is one where the trial court, after I think it was 19 pages in length, setting forth the reasons before it got to its decision, ultimately ruled that there were discovery violations that did not rise to the very high standard of fraud on the court. This court is now being asked to review that on an abuse of discretion standard, which is akin to asking whether any other reasonable jurist on earth would have done what Judge Metz did. And I think that this court can say on this record, given the standard review, especially, that Judge Metz did not abuse his discretion. I think what's really important here on this particular issue is to note that from start to finish, in every opportunity to disclose through every medium whatsoever, the defense here, Home Depot, that is, was aware of my client's prior cancer treatment, the drugs that she took, and she affirmatively disclosed, including to their own, and I think only expert, the neurologist, Dr. Goodman, that she believed she had polyneuropathy as a result of that. So the issue here is not whether Home Depot was unaware of the polyneuropathy that pre-existed this Home Depot incident, that it was neurological in nature, that there were some deficits in upper extremities. That's not the issue. They had all of those medical records. They subpoenaed them all. The issue here does come down to the failure to disclose the lawsuit. And I'm not sitting here this morning approving that it wasn't disclosed. But the issue here is Home Depot's not aware of the lawsuit in a particular or prompt manner, but even putting aside the conversation I had with opposing counsel's partner. So then the question turns on whether or not that would have met the standard. And I think Judge Metz did a really artful job of explaining why, at the end of the day, this did not rise to the level of fraud on the court. It's just a discovery violation. I read Home Depot's reply brief on cross appeal to basically insist on additional explanations. And I don't think, and I trust this court would agree, that sitting here on appeal now, this is not the opportunity to make additional records. There was a very long hearing. I believe it exceeded an hour. Both sides presented their positions and there was a verified motion. And given the way that this issue is presented on appeal and the standard of review, I don't think that we can say Judge Metz abuses discretion. On the other issues that
counsel, you agree that the trial court found that in essence, it was an intentional non-disclosure. It said his wording, I think, was it was not unknowing.
I believe that's true.
I don't know how you translate not unknowing. I would say that was intentional, but that the federal lawsuit was brought by your firm on behalf of your client after the Home Depot suit. It was not disclosed in any discovery response, and it was not disclosed or addressed really formally until after they filed their motion to strike. Is that correct?
I think that's generally true. All of that.
Okay, well, how is that appropriate?
The issue is not appropriateness. I'm not sitting here arguing that the manner in which the discovery went forth on the existence of this other federal lawsuit, I'm not saying that's appropriate. That wasn't our position below. Never was. It's not our position today.
Were any sanctions imposed on plaintiff or plaintiff's counsel for intentionally not disclosing a federal lawsuit that they had filed after this suit was underway?
No, and this is what I was going to say. I believe it's near the end of the order, although it's 19 pages in length. It could have appeared earlier. I think one of the other parts of Judge Metz's reasoning, which he makes clear on the record, is that at the end of the day, this was not a situation where it was the plaintiff in interest having sentiently putting forth some scheme, that at the end of the day, the discovery violations, which I believe you're correct, he phrased as not unknowing, were more problematic with me and my firm than it was to Mrs. Ader. And again, at the end of the day, the remedy that Home Depot is seeking here on cross appeal and what they saw below is throwing Mrs. Ader out of court. And I think what we have here is a situation where Judge Metz carefully weighed the interests and the facts and all of the law that governs and made the proper decision, even far and beyond just saying not abusing his discretion, carefully considered it all and said, look, at the end of the day here, this is a situation where Home Depot knew about the other potential cause, medically speaking, which is the critical evidence. Home Depot.
Right, you and your experts, and when I say you, plaintiff's counsel and plaintiff's experts, were quick to point out that her prior neuropathy or any nerve problems did not include the left pinky and ring finger. So you were trying to say that the cancer treatments and meds couldn't have caused the left pinky and ring finger because it never happened before, correct?
I see I'm out of time. Can I answer your question, please?
Please.
Okay, the short answer is yes, ultimately that was the issues. And it started with both experts. So because Home Depot had all of the historical medical records, this was a situation where they knew there was a pre-existing condition. It was neurological in nature. There was discussions about how it would manifest in an upper extremity. But to answer your question directly, there was no evidence ever spanning decades and volumes of medical records that she ever had those deficits in the particular fingers that were at issue in this case. So that's why the argument came that way. I know I'm out of time. I would just like to ask on the matter of appeal, we're asking for reversal for remand with new trial. But if not, short of that, then at least a partial remand for reversal with new trial on the issue of punitive damages. And obviously there were the issues of additor and things like that. On the issue of cross appeal, we're asking that this court affirm to say that Judge Metz did not abuse his discretion on that issue. Thank you for your time.
Okay, all right, counsel, thank you. We'll stand adjourned.